And can we begin with you?
Thank you. My name is Adrian Galley. I'm the Vice Chair of the South African Guild of Actors. Now, I like to consider myself an entertainer, as we are part of the entertainment industry, but I'd like to just refer to the two meanings of to entertain that are given in the dictionary. One is to provide someone with amusement or enjoyment, which is what I hope we do. But I do believe that the second definition of to entertain is not mutually exclusive to that particular one, and that is to give attention or consideration to an idea or feeling. So entertainers have a role to play in society, and we're part of the cultural economy, but more on that later, and the knowledge economy. Now, just this past Friday, the 29th of November, the SABC finally confirmed the rumors that have been circulating. It announced that the long-running daily drama Isidingo is to be shut down. The broadcaster rationalized, of course, that a decline in revenue no longer represented a favorable return on investment, and the channel's strategic direction lay elsewhere. A number of actors whose faces are indelibly linked to that series will be spending the coming holiday season considering strategies to secure their own financial futures, which have unexpectedly become very precarious and uncertain. Now, there will be no new episodes created, but the intellectual property will no doubt continue to be exploited in those global territories where Isidingo remains popular. Kenya, Nigeria, the rest of Africa, Argentina, and elsewhere in South America, the global south basically. And let's not forget the Encore channel on MultiChoice, and thereby hangs another tale. After 21 seasons of Isidingo, 5,500 episodes are in the can, in fact, in excess of that. And the rights holders will continue to see a return on their investment, but not one of the 75 or more principal actors who were part of those 5,500 episodes is entitled by law to a share of revenue by way of a performer's royalty. Now, musicians, which you mentioned, have enjoyed a statutory right to performance royalties for more than 50 years, thanks to the Performance Protection Act No. 11 of 1967, which granted protection of the economic rights of performers in phonograms, defined as an exclusively oral fixation. Now, that's the narrowest of definitions. It, of course, excludes future technological innovations. But as night follows day, the future began to happen the very next decade when television arrived on our shores, and the rights of performers in audiovisual media, as actors, were left completely unprotected. The march of time is relentless, and the future has continued to happen with the development of VCR technology, the advent of the internet, and the digital age that has heralded an explosion in the variety of platforms through which recorded or fixed audiovisual performances could be exploited. So we cut to the present. The South African Guild of Actors was very welcomed the opportunity to become engaged with the process of copyright reform. We made numerous submissions to the parliamentary presentations on both the Copyright Amendment Bill and the Performers Protection Amendment Bill. As the bills progressed through the various drafts and were passed through the National Assembly and the National Council of Provinces, actors became increasingly hopeful that for the first time ever, they would have a chance to derive some form of annuity income by way of performance royalties. We hear continually how actors end up dying as paupers. And this is one of the reasons there is no form of annuity income for actors. Now, even the most vocal opponents of the Copyright Amendment Bill agree that the Performers Protection Amendment Bill is long overdue. Some of them are suggesting that the PPAB should be enacted while the CAB goes back to the drawing board. In other words, they want to split the bills. So I'm not here to split hairs over the relative merits and demerits of the Copyright Amendment Bill. There are other people far more poised to do that in this room. I'm here to dispel any suggestion that the Performance Protection Bill can be separated from the Copyright Amendment Bill, and to assert that any attempt to suggest that they can be separated is just a disguised argument for both to be radically rewritten or delayed in perpetuity. Now, in short, the Performance Protection Bill cannot be put into effect unless the Copyright Amendment Bill is also in effect. There are both structural reliances and textual entanglements that underpin the relationship between the two bills, and I'll just run through a few of them briefly. The new rights granted to audiovisual performers, actors, require that a collective management organization is established and effectively regulated. That's to collect all of those royalties globally through reciprocal arrangements with other collective management organizations and manage that income and distribute it to the performers concerned. Now, the provisions for the effective regulation of collective management organizations lies in the Copyright Amendment Bill. So the rights granted to actors under the Performance Protection Amendment Bill would be meaningless in the absence of the Copyright Amendment Bill also coming into effect. The Performance Protection Amendment Bill contains no exceptions for disabled persons. So as a result of that, it is unconstitutional, or it would be if it was enacted by itself. However, the bill does contain an amendment to the Principal Act with the introduction of Section 82F, which allows exceptions for, quote, purposes which are regarded as exceptions in terms of the Copyright Act. Now, the Copyright Act to which that refers, if the Copyright Amendment Bill doesn't go through, is already unconstitutional because there are no provisions for people with disabilities. So the Performance Protection Amendment Bill requires the Copyright Amendment Bill to go through in order that it is constitutional. The Copyright Amendment Bill, as I mentioned, the current Copyright Act is unconstitutional because there are no provisions for people with disabilities, but the Amendment Bill has Section 19D, which provides for general exceptions regarding protection of copyright work for persons with disabilities. So that then renders them both constitutional. The Performance Protection Amendment Bill also refers disputes about royalties to the Copyright Tribunal, which is regulated by the Copyright Act. Now, Section 30 of the current Copyright Act only makes provision for, or gives the tribunal powers to adjudicate licensing disputes. The Copyright Amendment Bill gives the tribunal the power to adjudicate disputes over performers' royalties. Section 29A, subsection E, provides that the tribunal may settle disputes relating to licensing schemes, which it does already, payment of royalties, or terms of agreement entered into as required by this Act, or agreements entered into in order to regulate any other matters in relation to copyright. So, the Performance Protection Amendment Bill will only really be effective once that Copyright Amendment Bill is also in effect. The Performance Protection Bill also relies on definitions and provisions in the CAB with regard to copyright management information and technological protection measures. There are there are four whole sections of the Performance Protection Amendment Bill that will be rendered absolutely void if the definitions that are contained in the Copyright Amendment Bill are not in effect. So the PPAB makes direct references to the Copyright Act for definitions of copyright management information, technologically protected work, technological protection measures, and technological protection measures circumvention devices. Now, none of these currently appear in the Copyright Act, but they are in the Copyright Amendment Bill and will be given effect in that regard. The PPAB also makes reference to cinematographic, or deletes references to cinematographic films, replacing them with reference to audio-visual fixations. Well, that's the future happening right before us. The current Copyright Act still refers to cinematographic films. Now, combined with the competing interpretations of what constitutes a sound recording, the two terms, cinematographic film and audiovisual fixation, are mutually unintelligible. So those two bills need to both be enacted in order to make sense of it. And then there are a few more, like the PPAB amends Section 5, so that Section 5.5 refers to Section 8A of the Copyright Act. Well, the current Copyright Act has no such section. It refers to the amendment that is contained in the Copyright Amendment Bill. In a similar vein, but with an added little complication, which dramatists enjoy, actors such as myself enjoy little twists like this, there's the PPAB amends Section 5, so that 5.5 refers to Section 9A of the Copyright Act. Well, there is a Section 9A of the Copyright Act, but it is in fact replaced entirely by a provision in the new copyright provision of the Copyright Amendment Bill. So, if the Copyright Amendment Bill is not enacted, then the reference to 9A and the Performance Protection Amendment Bill refers completely to the wrong provision. In summary, the PPAB consists of 11 sections. 6 of those 11 sections rely on the Copyright Amendment Bill. Now, the Performance Protection Act is outdated by more than half a century. Many of our veteran actors rely on charity to cover their basic necessities. The resources of the likes of the Theatre Benevolent Fund, perhaps mercifully, do not extend to a DSTV subscription, where they might be exposed to reruns of their lifetime's work as they contemplate where their next meal is coming from. Thank you.
Thank you, Adrian. And sorry, my apologies, I should have introduced you.
Oh, no problem at all.
Okay, all right. I know Adrian's organization very well because I work a lot with your chairperson, Jack, who's an actor, who's been such a great activist.
Jack Devnarain, I'm sure many of you would know him.
From Isitingo, Rajesh.
When we were in Parliament, he'd already not been part of Isitingo for about 2 years, but he was referred to by his character's name. Now, this is how indelibly associated with a particular character an actor becomes.
Yeah.
So that while that intellectual property is being exploited further and they have no share in it, their opportunities are limited by the fact that he is Rajesh.
Yeah. No.